Good morning.
Morning, ma'am. Good morning, Miss Smith. Can you hear me?
Yes, I can.
Hi, you're scheduled at 9 o'clock. So if you want, you can come back or I can just leave you right where you are.
Okay, just leave me right where I am. I don't want no mistakes.
Okay, all right. Thank you.
Okay, thank you.
Yep, if you could just mute yourself.
Okay.
Thank you.
Mhm.
Good morning, Mr. McClung, can you hear me? Hi. Sir, can you hear me? David Shook, can you hear me?
Yes, I can hear you.
Hi.
I apologize.
That's okay. Miss Van Buren is in here. Do you need to go into a breakout room with her?
I'm always willing to, but I'm prepared to move forward.
Okay, all right, I'll let the judge know.
Okay.
Good morning, Mr. Levine. Can you hear me?
Good morning, yes.
Hi, good morning. Mr. Tatone just signed in. Is there any reason to go into a breakout room with him?
Always happy to talk if you'd like us to.
Oh, sure. Is that good, Mr. Tatone?
Sure.
All right, thank you.
Good morning. Today is Tuesday, June the 7th, 2022. I am Judge Martin. This is courtroom number 1. The docket today are civil matters. If you are not here, or civil and landlord tenant, if you're not here for a civil case or a landlord tenant case, you are in the wrong courtroom. And if you need assistance finding where you should be, please send a chat or a message to the court staff and they will get you where you need to be. I received an indication from my secretary that we have one case that is ready to go so far. And that would be 220451 GC. That's Sharon Van Buren versus Mulligan Heating. May I have the appearances, please?
Good morning, Your Honor. David Shook on behalf of the defendant, Mulligan Heating Incorporated.
Hello,
Hey, ma'am, would you state your name for the record?
My name is Sharon Van Buren. I am the plaintiff.
Thank you, ma'am. Today is the day and time set for the first pretrial conference in this matter. Have the parties had an opportunity to speak?
Not directly, Your Honor. To be very honest with you, it's been our experience with pro se that we're better off putting this on the record. It's our position that we complied fully with the terms of the warranty. So it's rare that I take that position. I am always willing to go into a breakout room, but we have not had a chance to speak.
Ms. Van Buren, do you think it would be beneficial to speak to Mr. Shook? Or are you ready to proceed with the pretrial?
I'm ready to proceed.
Okay. Because this is the first hearing in this matter, the court did have the opportunity to review the documents. And it appears that Ms. Van Buren's allegations that there was a 20-year warranty and this piece of mechanical equipment had to be replaced after 12 years. Is there discovery needed in this matter, Ms. Van Buren?
No,
Mr. Shook, from your perspective, is there discovery needed in this matter?
No, Your Honor.
Are the parties ready for a trial date, or Mr. Shook or Ms. Van Buren, are you looking for a motion date?
I'm
Your
just
Honor, if
looking, go ahead.
No, sorry, Mrs. Van Buren. Your Honor, I would request a motion date. I would plan on filing a motion for summary disposition. I think between the documents which she has provided and our documents which we have attached, I think Your Honor can decide on the pleadings.
Ms. Van Buren, do you intend to represent yourself, or are you looking to retain an attorney in this matter?
I'm looking to represent myself.
Okay, the court will set a final pretrial / motion date for July the 19th, 2022 at 9 a.m. back on Zoom, courtroom number 1. And if the motion from the defense is not dispositive, which means Ms. Van Buren, it doesn't resolve the case, we will schedule a trial date at that hearing date. If you receive something from Mr. Shook and you need to file a response, the response should be in writing. You should serve it on the court and serve it on Mr. Shook's office. Understood?
Yes.
Anything else, Ms. Van Buren?
No, that's all.
Anything else, Mr. Shook?
Your Honor, just simply so we're in the right place at the right time, we're in courtroom number 4, and you said it will be courtroom number 1 for the next hearing?
On our website, it calls it virtual courtroom number 4, but in reality, it's courtroom number 1. So
Just, sorry, Your Honor, I
notice
just
will
want to
have
make sure.
my-
Sorry, not
Your
to
notes
speak
will
over
have
you.
my meeting ID information on it. It'll be
Oh.
back here with me.
Thank you. Some of us old dogs have some problems with these new tricks.
I know, but hey, we're making do with what we have.
No, and thank
Anything
you
else,
for
Ms.
that,
Van
Your Honor.
Buren?
Yes, I'm fine.
Okay, I will see you back here on July the 19th. Have a good day.
Thank you, Your Honor.
Thanks.
Were we ready on Cherie Smith?
I think both parties are here, Your Honor. I haven't had a chance to talk to Ms. Smith yet, but I'm happy to proceed if that's something you like.
If you want to go into the breakout room with her, Ms. Smith, would you like to speak to the attorney before your case is called?
I don't know if he wants to, yes.
You'll see
Sure.
an invitation to join him in the breakout room. Please go there with him.
Thank
And
you,
when
Your
you
Honor.
come back out, I'll call your case.
Okay.
This is 215890 GC USA BioCare versus Diane Spencer and the estate of Eric Howard.
Good morning, Your Honor. For the record, Joseph Levine on behalf of the plaintiff. Sorry, John.
Sure. John Tatone appearing on behalf of the personal representative, Erica Drew, on behalf of the estate. I do not represent Diane Spencer.
Your Honor, we were last before the court about 4 weeks ago, at which time somebody else from my office appeared because I was in trial. But we had indicated to the court that we had what we believed was a tentative settlement with Ms. Spencer and her counsel, who has not appeared in this matter, but is representing her on a Wayne County probate court matter. Mr. Tatone and his client have answered the complaint. Ms. Spencer has not. We have not been able to reach a final settlement with them, although Mr. Tatone and I have had some discussions this morning about a possible resolution with his client that would resolve the entire matter. What I'm going to respectfully ask from the court is, given that we served the complaint on Ms. Spencer via her counsel in January, an acknowledgement of service was filed and timestamped with this court on March 2nd. We respectfully ask that the court enter a default and a default judgment against defendant Spencer only. That would be in the principal amount of $99.85, taxable costs of $203.70, and attorney's fees, which would be reduced per the contract of $2,400. That would be a total judgment of $12,588.77. If the court would enter that judgment against Ms. Spencer, I will submit it to you today. And then as far as the estate, we would defer to the court whether you would prefer to adjourn the matter for 30 days so that we can continue to try to work it out, or if you want to issue a scheduling order so the case moves forward on your docket. I think ultimately we're going to resolve it between the two of us. But if the court would allow us to proceed in that fashion, I think that would
Sir,
be.
my only concern
ideal.
is there, in your complaint, does it set out the attorney fees of $2,400? Or is it
It sets
contained
out-
in the underlying contract?
The contract calls for attorney's fees, but not for an amount. If the court does not want to order the amount of the attorney's fees, I would just ask for the judgment with the taxable costs and the principal.
The court did inquire when the parties appeared at the May 3rd pretrial regarding service upon and default upon the defendant number one. The defendant number one having failed to appear in this matter, the court will enter default judgment in favor of plaintiff and against Ms. Spencer for the amount alleged in the complaint, that $9,985, the taxable cost to date of $203.70. If you want to submit for the statutory attorney fee, the court will sign a default judgment in that amount. Anything else would require additional documentation from your office regarding the attorney fees sought. As for defendant number two, the last time we were here, the indication was that we were adjourning for order, payment, and dismissal. I'm happy to adjourn it another 30 days if you want to come back on the, what is it, Mary Ann, July 6th docket? Will that give you sufficient time?
I think it will, as long as we can get the judgment. And ultimately, what we're going to have to do, Your Honor, potentially is enter the judgment, wait 21 days, and then I would have to request a garnishment. Mr. Titone's client actually holds the funds that would be part of the settlement, but they're subject to a Wayne County probate court order. So if the court could give us another couple of weeks, that should give us enough time to take care of the paperwork and allow for service of the necessary documents.
So
Your
not
Honor-
the July date, are you looking for the August civil date?
I don't know what that is, Your Honor. I know I'm going to be gone the first 2 weeks in August, so I might not be asking for that date.
Mr. Titone, you were starting to say?
Sure. Do you have another date available in July, July 6th? I have conflicts.
We could do July the 19th.
I think that would be good. Mr. Levine?
Same time, Your Honor?
At 9 a.m., yes, sir.
It should be good. I'm scheduled to start a trial on the 18th in Oakland County Circuit Court, but I'm 90% sure that's going to go away. So if we can have the 19th, that'll be great. And if that 10% comes up, we'll contact the court immediately.
July the 19th at 9 a.m. The only thing I would say is if you are going to be stuck in trial, reach out to my secretary, Mary Ann, and we'll just adjourn it over. If that August 2nd date would be my next civil date, but you're not available, one of you is on vacation for those first 2 weeks, the next date would be August the 23rd. So
Okay.
anything else on behalf of the plaintiff?
Does the court accept submission of documents electronically? For
Absolutely.
the, you want me to fax the default judgment or should I email it?
You can email it. If you open your chat, Taylor, the civil clerk is going to put the civil department's email in that chat. You can send it to them. They'll bring it up to me.
Thank you, Your Honor. I'll have it to you this
So
morning.
The default judgment as to defendant number one, the pretrial on July 19, 2022 at 9 a.m. by Zoom for courtroom number one is as to the plaintiff and defendant number two only. Anything else, Mr. Levine?
No, thank you. I appreciate your time this morning, Your Honor.
Anything, Mr. Titone?
No, no, ma'am. Thank you.
You're so welcome. Have a great day.
You too.
Thank you, Your Honor. Thank you, Mr. Stone.
Good morning, Mr. Beach. How are you, sir?
Good morning, Judge. How are you doing today?
I am super. It's good to see you.
Nice seeing you too.
I don't see. Mary Ann, you have to reset me as co-host. I can't see who's where. And to the person with the night t-shirt on, with the television over your right shoulder, your name, please?
My name is Evan Brooks.
Good morning.
Good morning, ma'am.
Let's get you labeled correctly. Mr. Brooks,
Yes.
what type of case do you have, sir?
I was told I had a Zoom meeting today. I believe it was
That's-
like 9 or 9:30, and it was for sexual assault.
You're in the wrong courtroom on the wrong day, maybe. Sit tight for 1 second. They'll look up your case. I'm not doing criminal cases today. I think that's tomorrow's docket, but don't leave. They'll look you up and we'll get you where you're supposed to be.
All right. Thank you so much, ma'am.
You're so welcome. Are we ready on Smith?
We are, Your Honor.
This is 221491 GC, LVMV funding versus Sharice Smith. May I have your appearances, please?
Preston Nate, P77884, appearing for LVNV funding.
Ms. Smith, if you would just state your name for the record.
Hi, my name is Sharice Smith.
Thank you, ma'am. Today is the day and time set for the first pretrial in this matter. The parties have had an opportunity to speak. Mr. Nate, do we have a resolution this morning?
We do, Your Honor. We talked to Ms. Smith for a bit. We're going to go ahead and set up a consent judgment with a payment plan that works for her. So I'll be mailing that out to her today, and then hopefully we can get that into the court relatively quickly.
What are the terms of that consent judgment, sir?
The damages, $1,135.86 plus the court costs of the filing fee and service fee for a total of $1,230.34. And Ms. Smith's gonna pay that over $50 monthly payments starting July 25th.
On July 25th.
25th.
Thank you.
Yep.
Ms. Smith, you wish to enter into an agreement with Mr. Nate that you will pay a total of $1,230.34 at $50 per month beginning July 25th, 2022?
Yes, ma'am.
What'll happen is he will send it to you, you'll sign it, you'll send it to him, he'll sign it, they'll send it to the court. Once it comes to me, I will sign it. The court staff will mail copies to you that will resolve this matter. If this court has not received that consent judgment within 14 days, you will likely receive a notice of intent to dismiss for lack of progress. So Mr. Nate, please be timely in getting it out, and Ms. Smith, please be timely in getting it signed and back to Mr. Nate for submission to the court, okay?
Yes, ma'am.
Anything else on behalf of the plaintiff?
Not on this case, Your Honor. That sounds good.
Anything else, Ms. Smith?
No, ma'am.
Ms. Smith, thank you so much for your patience this morning. You're free to leave. Have a good day.
Okay, thank you.
Thank you.
Thank you.
Mr. Brooks, how do you spell your name?
Evan, EVAN, BROOKS.
I don't see anything at the 34th District Court with your name on it.
So they had gave me this Zoom meeting a few days ago. I could barely understand the lady speaking to me. And she said, I want to say she said the 7th at 9 or 9:30, and I wasn't sure on the time. So I had joined at 9 to make sure. But she had gave me this Zoom meeting code, and it's been in my phone for 4 or 5 days. And it actually let me join today. I've tried to join on other days and it wouldn't let me join.
It might not have let you join because we weren't in session. Mr.
Okay.
Brooks, are you a witness or a party?
I would believe it would be party.
Do you have any paperwork regarding
No.
the case?
No, I don't have any paperwork or anything. They called me over the phone and told me this. They didn't send me an email regarding anything.
He's not in our system, Judge.
I know, I'm looking myself. Mr. Brooks, I don't want you to miss a case. I don't want you to miss a hearing of any type. Let's think about how else. Where did this, the thing that brings you to court, where did it happen, sir?
It happened at the Red Rooster in Willis, Michigan.
And are you the person charged?
No, I'm going to be the person charging.
Okay, who is the person that was charged, sir? Do you
I'm
know?
Last name, but first name would be Jacob.
Jacob?
Yeah, I don't know his last name.
Okay. Mr. Brooks, what I'm going to have you do is go into a breakout room with Taylor. Taylor, get his contact information. He is not on our docket. He's not on our books. We have to find where you're supposed to be, sir, but this courtroom today is not the right place, but I will follow up with the clerk as soon as I get done with the docket, okay?
Okay.
So go into the breakout room with the clerk. She'll get your information and we'll get back in touch with you, okay?
All right. Thank you.
Thank you. Mr. Beach, you need to speak to Mr. Brown.
If he's there, I didn't know he was here. If he's there, I'll speak with him, sure.
He just popped in.
Okay.
They'll get you into a breakout room. Mr. Brown, please join the attorney to discuss this CAC, this credit acceptance matter, okay?
The person that's listed as Liz, can you hear me?
Yes, I can.
What is your name, please?
Liz Casto. I'm here for the Genevieve East hearing that is at 9:15.
There is no such hearing on the docket, ma'am. Not at 9:15. It's at 9:30.
Oh, yes, I'm so sorry. Yep.
What is your relationship to the case?
I am here in place for the property manager.
If you sit tight when we get closer to the 9:30.
Yeah, that's perfect.
Renner and thank you.
Awesome. Thank you so much.
What case, what was the case? Which one at 9:30?
It's 220221 LT, Integrated Property versus Genevieve East.
Thank you.
Taylor, were you able to get sufficient information from Mr. Brooks?
I got all his contact information and he was a victim.
That's what I thought, but I want to make sure that he doesn't miss the hearing that he's here for.
I'll talk to Marlisa.
Thank you so much.
No problem.
I think I might have a name of who he might be here for. He said the first name was Jacob. We have at 9:30 tomorrow, a Duzan is the last name. So you might, I don't know, that might ring a bell to him. I'm not sure.
Okay, I'll let Marlisa know.
Thank you.
I give someone an A for effort for trying to get here, and I just didn't want to leave him holding on this docket when I knew that this was not where he was supposed to be. Somewhere
Right.
else maybe, but just not here today. Man, busting up through here like that.
Sorry, let's go ahead. To get these lights fixed and locked up.
That light's gonna finally get fixed? Wait,
Yeah.
uh-oh.
And as soon as we fix them, another one goes.
So Marianne, the first farmer's market for Belleville happened last night.
Oh, it was such, wait, it rained though, didn't it?
But I don't know if the rain was bad. I was bummed because I missed it. I was, even though I saw signs downtown, my mind was still telling me that it was next week. So I have to be better. It's from 4 to 7:30 on Mondays.
I'm really gonna take my mom there this year. I know I said that last year. It starts now through the whole summer, right? Every Monday.
And there's always something nice. I got Tupperware there last year.
Did you just say Tupperware?
I said Tupperware. I bought Tupperware there at the farmer's market last year. That's where we won the raffle with that Yeti cooler, that the Belleville Auxiliary Fire Department or something, that giant Yeti they were doing a raffle. They put so much effort into it and they have such nice vendors who come.
Judge,
Taylor.
Marlisa is calling him. It's tomorrow at 9:30.
Thank you so much for following up with him.
No problem.
So Marianne, you should have seen the guys that were cleaning the men that were cleaning the windows yesterday. They were cleaning the bus shelter on the first floor.
They did all of that too?
Yes. The one guy had this long, narrow bucket and he had what looked like a big dust mop. That's what he was, or the sponge. So he put it in there and then he would reach it up over the that shelter. I call it a bus shelter, but that's not what it's called, the indoor glass enclosure by the front door. The thing looks beautiful. I don't know if they cleaned the inside of the first floor. I know they were supposed to, but I didn't stay around and watch that part. That is such a skill.
But
Cleaning those windows.
They were so quick. They were in and out of my office. I don't know if you were in your office when they did your window, but it was like they were 2 seconds. They got it down.
I knew they were coming. They told me in the morning that they were coming. So I just moved the stuff out of the window ledge and he was just starting when I took the bench. And when I came back, I couldn't tell he'd been there. I mean, it was perfectly clean, but he didn't leave anything. No, not a drop of anything anywhere.
Yeah, I know. I asked him if they did residential. And he said no, unfortunately, because my mom's house is made out of glass. So I thought we're always looking for somebody.
The cleaning lady.
The cleaning lady does windows?
The referral lady, she did my mother-in-law's.
Yeah, but I wonder
don't know if she does.
Go ahead.
I'm sorry, I was just gonna say, I don't know if she would do upstairs, outside, but she did the first floor inside and out.
Huh, I'm gonna have to ask her, because they're gonna have to get scaffolding or something in my mom's house. Nobody, they say, yeah, and they come over and like, no.
Here's Miss East. Good morning, Miss East.
Good morning. Can you hear me?
How are you, ma'am?
I'm fine. There we go.
Just waiting for the attorney for integrated property. Are we expecting Ivan Dunham this morning?
He's at the hospital right now, so he won't be available.
When Mr. Renner appears, we'll get this case called and get you on your way as soon as possible, okay?
Thank you.
You're welcome. So Marianne, I'm a fan of putting the request out into the universe and saying on social media, hey, I'm looking for a window cleaner that can do inside, outside on a 2-story and see what happens. That's how I found a plumber and a landscaper before.
Yeah, that would be awesome. Wait, what do you, like, where do you put it? Like out on Facebook or just, you have your own places that you put it out at?
I just was, I'm trying to think, the plumber was like a community-based page, but when I was looking for somebody to cut the grass, I just generically put it out on Facebook. I need somebody to cut a grass for a house in Detroit. And the guy who, it was, I'm trying to think how, it was a friend of my cousin who reached back out to me, and he cut the grass at that house for 10 years.
Oh, well, that, you scored on that. Well, so did he, I guess.
I think I saw him maybe 3 times in that entire 10 years because he would cut the grass, send a picture, and I would send him a check. And then later on, I would send him the Cash App when that became a thing. But that's how I found him on. Are the parties ready on 221002 GC credit acceptance versus Dennis Brown?
Plaintiff's ready, Your Honor.
Your appearance, please, sir.
Good morning, Your Honor. Michael Beach, BEACH, P45459 for the plaintiff.
Mr. Brown, state your name for me, please, sir.
Dennis Tyree Brown.
Thank you so very much. Today is the day and time set for the first pre-trial in this matter. The court has reviewed the pleadings. The parties have had an opportunity to speak. Mr. Beach, is there any resolution of this case this morning?
Good news, Your Honor. Yes, there is. I talked to Mr. Brown and we're in agreement that he's going to enter into a consent judgment. The total amount of the judgment with cost and statutory attorney fees will be $9,796.12. He's going to pay that at the rate of $100 per month, with the first payment being June 30th of 2022. Also, our client is offering a settlement, possible settlement on this, and this will be reflected in the consent judgment that if he pays a total of $1,960 by August 7th of this year, they'll accept that as full settlement and satisfy the judgment.
I'm sorry. So a consent judgment of $9,796.12 at $100 per month, or a settlement of $1,960?
Yeah, a settlement of 1,000.
Okay.
Well, the thing is, it's a sort of an and, so he'll need to make his payment this month, his $100 payment, and that will be applied to the settlement amount if in fact he pays the remaining. So if he pays $100 this month, he'll owe $1,860 next month if he wants to settle.
Mr. Brown, were you able to hear Mr. Beach just now?
Yes, ma'am.
And sir, you wish to agree to the consent judgment of $9,796.12 at $100 per month, with the first payment being due on June 30th, 2022.
Yes, ma'am.
And Mr. Beach, how will that consent judgment be executed and submitted to the court?
I received Mr. Brown's email address. I'm going to go ahead and prepare the consent judgment, email it to him. And I've instructed him to sign the consent judgment and scan it and send it back to me, and we'll submit it to the court, Your Honor.
Thank you. Mr. Brown, I'm going to make a notation in the file that we'll have that consent judgment within the next 14 days. So when you receive it from Mr. Beach, unless you have any questions of him, please sign it, get it back to him so he can sign it, get it over to the court. I'll sign it, and then the court clerks will mail a copy to your attention. Okay, sir?
Yes, ma'am.
Anything else, Mr. Beach?
Nothing further, Your Honor. Thank you.
Anything else, Mr. Brown?
No.
Mr. Brown, have a wonderful day. You're all set to go.
You as well. Thank you very much.
Thank you. Take care, Mr. Beach.
Take care, Judge. Nice seeing you.
Good morning, Mr. Werber.
Good morning.
How are you, sir?
I'm doing well. How are you?
I am good. Do you need to speak to Mr. Hoagland?
That would be great. Yes.
Marietta will get you moved into a breakout room.
Perfect. Thank you.
Good morning, Mr. White. How are you, sir?
I am well. How are you?
I am well, thank you. Do you need to speak to Ms. East or are you ready to proceed?
I think we're ready to proceed, Your Honor.
This is 220221 LT. This is integrated property versus Genevieve East and Ivan Dunham. May I have your appearances, please?
Yes, Dylan White, P 80755, appearing on behalf of Integrated Property Services.
Ma'am, please state your name for the record.
Genevieve East.
Thank you. Today is the day and time set for hearing. On plaintiff's request to lift the Sarah stay. That stay went into effect on February 2nd, 2022. 124 days have passed since the entry of that stay. Mr. White, where do we stand this morning?
We haven't received any sort of money or payments from Ms. East or from Mr. Dunham. So we would just ask that a possession judgment be entered in this case, Your Honor.
We lost Ms. East. I'm bringing her back in.
There she is.
Ms. East?
Sorry, the phone hung up on accident.
That's okay. Mr. White just indicated that plaintiff has not received payment in this matter. What's the status of Sarah application?
I talked to Sarah yesterday and they told me you're gonna have to give me a deferment or a decision for them to make it go faster. Cause I'm still at the pending viewing. And when I spoke yesterday, they told me that my landlord had to send a new ledger out. I spoke to the landlord. She said she sent one, but she told me to get them to go sir, I'm not saying the program right. Told me to get them to go faster. You need to give me a decision.
I will do that. Mr. White, how much rent is due owing to your client?
Rent to retain possession, including June's rent and other costs, is $5,877 plus court costs, and a money judgment in this case as well, Your Honor.
How much are the court costs, sir?
Looks like $55 plus $75 plus $26. How come I don't have that there? Let's real quick calculate that. $156, Your Honor.
$156 in cost and $5,877 of rent through June.
Yes, Your Honor.
Ms. East.
Yes, ma'am.
Do you acknowledge and agree that $5,877 in rent is due and owing?
Yes, ma'am.
And you understand that plaintiffs are entitled to court costs once they file this case to collect those past due rents?
Yes, ma'am.
That shows a total of $6,033.
Yes, ma'am.
Ms. East, inasmuch as you agree that that is the amount that is due and owing in this non-payment of rent matter, there is not a tribal issue. Plaintiff is entitled to have that Sarah stay lifted and for judgment to enter in this case in that amount. What will happen is Mr. White's office will submit that judgment to the court electronically. The civil department's email address is in the chat. You'll get a copy of it once the court signs it, and you can take that document to the Sarah agency that you applied with, and hopefully that will speed up the release of the funds.
Okay.
Anything else, Mr. White?
No, Your Honor. Thank you.
Anything else, Ms. East?
If the judgment, how soon do I have to move out if Sierra doesn't give the funds?
By statute, ma'am, it's 10 days to pay or move, but I have notifications in the file that there is a Sarah application that remains outstanding. And Sarah, whatever agency you submitted your application to, they're aware of it. And if they told you to get a decision from this court to expedite things, make sure that as soon as you get a copy of the signed judgment, that you get it over to them and stay in communication with your landlord. If you receive information from Sarah that there's a check that's on its way or imminent, or let your landlord know so that they will expect it and not proceed any other way, okay?
Okay, thank you.
Thank you, Ms. East. Have a good day.
You too now. Bye.
Thank you, Your Honor.
You're welcome. Mr. Hoagland's in with another attorney right now, sir. If you want to sit tight, when he's out and available, we'll get you matched up and in with him, okay?
Thank you, Judge.
You're welcome. Good morning, Mr. O'Connell.
Good morning, Your Honor.
How are you, sir?
I'm fine. Yourself?
I'm good, thank you. Mr. Werber, was that sufficient time?
Absolutely. We are all set. We have reached a consent judgment.
Give me 1 second. This is 221425GC. This is Portfolio Recovery versus Stephen Hoagland. May I have your appearances, please?
Yes, good morning, Jeff Werber, P67124 on behalf of the plaintiff.
Sir, unmute yourself and state your name for me, please.
My name is Stephen Hoagland.
Thank you. And Mr. Werber, that resolution?
Yes, Your Honor, we have reached a consent judgment. The total balance is $2,290.03 plus court costs. And the defendant is going to make payments of $100 a month starting July 25th, 2022, and on the 25th of each month thereafter. I will prepare a consent judgment with installment payments, mail it to Mr. Hoagland for his signature, and then we'll get it filed with the court.
Mr. Werber, do you have those court costs in total available?
Absolutely. It's $75 filing fee, a $58.46 service fee, and a $20 motion fee. And I'm going to add these up for you. 5 plus 58, 46 plus 20. Total court costs are $153.46. So the total amount of the judgment will be $2,443.49.
Mr. Hoagland, is that what you wish to agree to this morning, a consent judgment with a total due of $2,443.49 with payments of $100 per month beginning July the 25th, 2022?
Yes.
What will happen next is Mr. Werber's office will prepare that consent judgment, send it to you for signature. Once you sign it, send it back to their office. They'll countersign it, mail it into the court. Once the court receives it, I'll sign it and a copy will be mailed out to you at the address we have on file. If that's not done, the court has not received that consent judgment within the next 14 days, you'll likely get a notice of intent to dismiss for lack of progress. Anything else, Mr. Werber?
No, thank you, Your Honor.
Anything else, Mr. Hoagland?
No, I'm set.
Thank you. Mr. Hoagland, you have another matter of Midland funding. We'll get you moved into the breakout room to discuss that case with that attorney, okay?
Okay, thank you.
Thank you. Good morning, Ms. Butler. Mr. O'Connell, have you been in contact with Mr. Ivanchik about this case?
Not since the summary disposition hearing in January.
This is 221028 GC Midland Credit Management versus Stephen Hoagland. May I have your appearances, please?
Good morning, Your Honor. J. Latif Beg, BAIG, P 36820, appearing on behalf of plaintiff and the attorney of record.
Mr. Hoagland, would you state your name for the court, please, sir?
Stephen Hoagland.
Thank you. Today is the day and time set for the pretrial in this matter. The parties have been in the breakout room. Mr. Beg, do we have any resolution of this matter?
Yes, well, we're going to do a consent judgment with installment payments. Shall I put the particulars on the record?
Yes, please, sir.
Okay. Consent judgment damages $581.76. Costs of $100.58, consisting of filing fee of $35 and service of process $65.58. No statutory attorney fee. Total is $682.34 to be paid at a rate of $50 a month starting July 15th of 2022 and due on the 15th of each succeeding month until fully paid.
Mr. Hoagland, were you able to hear Mr. Beg just now?
Yes, I was.
And it's your understanding and agreement that the parties will enter a consent judgment totaling $682.34 with payments of $50 per month beginning July 15, 2022?
Yes.
And Mr. Beg, how will that consent judgment be submitted to Mr. Hoagland for signing?
We could do that
Email
or
snail mail is what I'm asking.
what?
Email or snail mail is what I'm asking.
Well, if he gives me his email address right now, I'll send it to him.
It doesn't matter to me. I just want to be sure because I'm putting a note in the file that says 14 days for consent judgment. So however it is that you've agreed to it.
Well, how about if we do this? Can we just do it under the 7-day rule? Is that would that be fine, or would you just prefer it?
7 day is absolutely fine. Mr. Hoagland, what the attorney is saying is that he will submit the consent judgment directly to the court with the terms placed on the record. And unless you do not agree, if you agree with what he submits to the court, you don't need to do anything. If you think what he submits is not an accurate reflection of what the party's agreement is, you can file an objection and get the matter back on the court's docket.
Okay, that's fine.
Okay. Anything else, Mr. Beg?
No, that's good. Thank you, Judge.
Anything else, Mr. Hoagland?
No, I believe I'm all set. Thank you so much.
You are, sir. Thank you so much. Have a good day.
Thank you.
Do the parties need to speak on Butler versus Delta Airlines?
I'm always open to talking, Your Honor.
Before you go into the breakout room, this case got sidetracked and I'm not sure how. When we were here on January 4th, my note says case evaluation on plaintiff's motion, plaintiff to submit the order. And then the case became stuck in the civil department. So I had the clerks scheduled to get you back here just so we could resume a conversation and get the case moving forward some way.
Okay. Yeah,
That being
if the
said,
court
Mary Ann
recalls,
will get you into-
I came into I thought we had a hearing for this back in, I want to say March. I think the court told me the same thing then, and I just kept forgetting to draft the order.
It's fine. Mary Ann will get the two of you into a breakout room. Do you want Ms. Butler to join you or should she stay in this main session?
Main session for right now.
Okay,
Thanks.
thank you.
Thank you.
Mr. Nate, your next case is Atherton at 9:45. I don't see your defendant as of yet. My rule is 15 minutes after the scheduled start time. So if they're not here by 10 o'clock, I'll call it for default, okay?
Yep, that sounds good. And just so you're aware, I also have a 10 o'clock with you, the Titus Hayes case. So if by chance he logs
Okay.
on, I'm available.
And then 11 o'clock, so yeah,
Yep,
you'll be with me
and
for
11,
quite a
you're
while
right.
this morning.
A few of
Thank
them.
you.
You're welcome.
Mr. Hayes is here.
I'm happy to meet with him if you'd like to.
Hello.
Good morning.
Titus. Yes, good morning. Sorry, he's on his way right here.
That's okay. I'm going to get you moved into, you'll see the invitation to join the attorney in a breakout room. Please go there to discuss the case, okay?
Okay, thank you.
Taylor, why were you out? What happened?
Well, there you go.
No, she had gone out.
I accidentally,
just let her.
I closed I'm on my phone and I closed the app. Because I'm all over the place.
Are you at the front counter this morning?
Yep.
Is there not a speaker? You can't, oh, you know what? Okay, I know. Is there anything going on today? Let's look at the calendar for today. There's a lot of stuff going on, Marianne. Holy smokes. I don't know how Taylor wound up with 2 civil dockets on the same day. Good morning, Mr. Neal.
Good morning.
How are you, sir?
Not too bad. We had a hearing first pretrial for Michigan First versus Mason. We'd submitted a stipulated order for dismissal. Has the court received that?
Received it, signed it yesterday, and it is back downstairs already.
Perfect. Thank you.
Anything else this morning?
That is all I have. I appreciate it. You have a good morning.
You too, thank you. Okay, Marianne.
Yes.
Are you still doing Wordle?
Oh, that's very frustrating. Not so much. So do you remember? We're live. I'll ask you this later. It's that's a challenge. So I've got to just maybe every few days, and I'm not very good at it.
Just just trying to keep the mind sharp, you know?
I think I'm doing okay on Words with Friends, and then I go on Wordle, and it's just like,
I grew up watching my dad do crossword puzzles, and I still do them online and on paper. I don't have a preference one way or the other. But my dad, always still has these crossword puzzle books, and when I've traveled with him,
Hi, Your Honor. If you wouldn't mind, can you put me in a breakout room with my client? I didn't get a chance to talk to her before the hearing today. I got diagnosed with COVID on Thursday.
Marianne will get you moved.
Okay, thank you.
Oh, no, she just put your client in with
Yeah,
Mr.
I'm gonna-
Crown. Give her a
sorry, I'm
second,
gonna-
she'll switch them.
I'm gonna fix that, sorry.
No worries.
That was interesting. That's how I felt when somebody put me in the breakout room last week. I was in there with,
I remember that. It's like, whoa, wait, where's the leader of the pack? Where'd she go?
so Taylor, have you been next door to talk to the Wayne Metro people yet?
For what? I don't even know who those are. Who are they?
To go be neighborly?
Who are they? Where are they?
Wayne Metro is in the old courthouse. And those are the people who do the Sarah applications.
Oh, I wondered who they were.
The big old purple van that says Wayne Metro.
I didn't see that.
You have to talk about your skills of observation.
I just see the cars over there. I didn't see a van.
And you weren't curious about 10 cars for a building that had been unoccupied for a year?
I figured it was okay. I was gonna ask somebody, but I sidetracked.
You could have asked Garcia. I'm sure he would have been happy to explain to you what was going on over there.
Oh. I thought they were doing explosive stuff in that building.
They do training. Airport Bomb Squad was doing training, I think. But now that there are tenants in there, I'm thinking that there's no more bomb sniffing dogs. I'm going on a limb with that one. Mary Ann, my only problem is that I want to know the basis of her suggestion that this matter will not be proceeding.
The dates of, well, I'll talk to you when we're done. Because there might be a possibility that it would go, right? She said possibly dismiss it, possibly.
I might possibly be a prima ballerina at the end of this month. I don't think that's gonna happen. Mr. O'Connell, see, I knew I could make you smile. I just had to keep on with my A1 material.
I got all morning, Your Honor.
You bet. Good morning. Can you see me?
Good morning, Mr. I can
Hey.
see you.
Oh, okay. I didn't see you. Okay, how you doing? This is Titus
I'm
Hayes.
good. Give me 1 second. Hold on 1 second. Let me, there's a case that's scheduled earlier than yours. Was that sufficient time with your client, sir?
You talking to me or someone else?
No, I'm talking to Mr. Ivanchik that just came out of the breakout room.
Okay.
Yep. Sorry, Your Honor. I was just asking
That's
asking your clerk to put me and Mr. O'Connell in a breakout room really quick.
Absolutely.
Thanks.
Thank you.
This is 221017 GC. This is LVNV funding versus Titus Hayes. May I have your appearances, please?
Preston Nate, P77884 for LVNV funding.
Mary Ann, would you put Mr. O'Connell and Mr. Ivanchik back in a
Yep.
breakout room together?
I will.
Mr. Titus, state your name for the record. Mr. Hayes, state your name for the record, please, sir.
Titus Hayes.
Thank you. Today is the day and time set for the first pretrial in this matter. How are we proceeding?
So we were able to talk about it, and we did work out a payment plan that we're going to go ahead and do with Mr. Hayes. We're going to do that under a conditional dismissal. He's going to have that paid off relatively quickly. And I can give you the court the numbers. So the charge-off balance was $697.37. There are court costs, but we're gonna forego those in the conditional dismissal. So it would just be the $697.37. And they're gonna do $200 a month starting June 15th.
Mr. Hayes, were you able to hear Mr. Nate just now?
Yes.
And sir, you'd like to agree to a conditional dismissal where a total of $697.37 is due with a payment plan of $200 per month beginning June the 15th, 2022?
Yes.
Thank you, sir.
You're welcome.
And were you submitting that to him by email or were you mailing it to him to sign, sir?
I was gonna mail a copy to him to sign, and then they can mail that back to me so we can get that into the court.
Thank you. Mr. Hayes, when you receive that conditional dismissal, please sign it, get it back to the attorney's office so they can sign it, get it to the court for entry, okay?
Yes. Yes.
Anything else, Mr. Nate?
Not for this case, Your Honor. That sounds good.
Anything else, Mr. Hayes?
No, ma'am.
Thank you. We're all set, sir. You have a wonderful day. Thank you for joining us.
Thank you. All right. Bye.
This is, bye-bye. This is 220323 GC. This is LVNV funding versus Kelly Atherton.
Good morning again, Your Honor. Preston Nate, P77884 for LVNV funding.
This matter was scheduled for pretrial at 9:45 a.m. It's now 10:03 a.m. by the court's clock. Defendant has failed to appear. There are no unidentified persons in the court's virtual courtroom. There's no one in the court's virtual waiting room. How would you like to proceed, sir?
Well, Your Honor, as an update to the court, it looks like this defendant is working with a debt settlement company who did call our office and managed to work out a payment plan on a settlement amount with them. We did get a consent judgment sent off to them, but it wasn't mailed out until the June 2nd. So I'm not sure if it'd be possible to maybe just adjourn this pretrial and give us a chance to get that consent judgment signed and into you. I think it shouldn't take too long.
We will adjourn the pretrial to that July 6th, 2022 at 9:15 a.m. if we receive it, the consent judgment before that date, of course, we'll sign it, get it back to the parties, and you will not need to appear. Anything else in this matter, sir?
I know that sounds great. Thank you, Your Honor. And as you said, I do have one with you at 11, but I will log back in for that.
We'll see you later.
Yep.
Good morning, Ms. Cooper.
Good morning, Your Honor.
How are you, ma'am?
I'm doing fine. How are you?
I am wonderful. This is 215275 LT. This is Majoric versus Gregory Matthews and Danielle Matthews.
Yes,
May I have your appearance, please?
of course. Catherine Cooper with Lakeshore Legal Aid on behalf of defendant P85148.
Ms. Cooper, have you received any response from the plaintiff regarding your motion?
I have not, Your Honor, and I did mail it to them. I believe my proof of service is in the pleading, so I don't know. But I know Mr. Matthews has paid in full, and we were trying to reach out to Mr. Mayercheck so that he could just file the, the scowl copy of the satisfaction of judgment. And then, unfortunately, Mr. Mayercheck informed me in March that he was going to Ukraine to visit family members. So I don't know if he's still out of the country or if that is the holdup or what. But I know his son is here, and they typically conduct business together. But
Ms. Cooper, the court reviewed your motion when you filed it. There is no defense to payment in full and the issuing of the satisfaction. The court's going to grant your motion. I've signed the satisfaction judgment. It'll be back downstairs shortly. Anything else in this matter?
No, Your Honor.
Have a good day, ma'am.
Thank you. You as well.
Good morning, Mr. Joseph.
Good morning. How you doing?
I'm super. How are you, sir?
I am doing well. Good to see you.
It's 10:07. You're scheduled at 10 o'clock. I usually wait about 15 after the scheduled start time. So if you would sit tight for a little bit, we'll see if the defendant appears.
Okay, that sounds good. I'm going to hop over to a waiting room in another court, so I'll just keep an ear out for when you call it.
Thank you, sir.
Yep.
Are we ready?
Yes.
Yes, Your Honor, sorry.
This is 213740 GC. This is Teresa Butler versus Delta Airlines. May I have your appearances, please?
John Ivanchik on behalf of the plaintiff Teresa Butler, who is here but still muted, looks like.
And Tim O'Connell appearing on behalf of defendant Delta Airlines.
I'm here.
Okay.
Thank you. How are we proceeding this morning?
The way that we were supposed to back in January, which is to set it for a case evaluation. Counsel and I have discussed to try to resolve this case this morning, but we've been unable to reach a resolution. We're going to continue to try to negotiate and hopefully reach a resolution without the need of case evaluation. But just as a precaution, move it that way. Unless the court's got a better idea.
Well, not a better idea, just a different idea. Judge Green is a certified mediator. If you want to do it as an in-house mediation, we can get on her schedule. Just as
I
an
have
option, since
no
we've
problem
been
with
kind
that.
of hanging around for a while.
Yeah, I did not know that Judge Green does that. Is it through the court or is it private?
It's through the court. She and I are both ICLE certified mediators, and we had the conversation that there's no reason for us to send these files out if the attorneys want to consent to mediation in-house, and these cases are scheduled as bench trials. we can keep them here. We can get you on her schedule if that's something you're interested in.
I would be more than happy to do that. Teresa, do you understand what that is?
Yes, I do.
Perfect. Yeah, any problem with it?
None.
Perfect. Yeah, I'm fine with that, Your Honor.
Well, I don't want to stall the process any more than it has been already, but frankly, Your Honor, I think that's a request I probably need to take to the client. I was not prepared for that today. I can certainly ask, and I can guess that they would be amenable to that, but I can't speak for them.
Well, I don't want to undo the conversation that the two of you have had. And if your agreement is to go to case evaluation, we can do that. It doesn't, I have no preference. I just wanted to.
Your Honor, if I may, as Mr. Evanchek mentioned, we did have some discussions. I will take some of those discussions to my client, and in the process, I can also raise to them the issue of mediation. And I guess get back to Mr. Evanchek in both respects, if it makes sense to do that.
Yeah. So if we did consent to mediation, or all parties consented, Your Honor, what would we need to tell the court?
I would have my secretary call down the hall to Judge Green's secretary and get a date for mediation with her right now.
Oh, okay.
So, because otherwise I would have to put it over if we don't have an agreement as to how we're proceeding, whether case evaluation or in-house mediation. I would have to give you a new date to kind of control us. So you tell me.
Tim, how long do you think it would take to get a response back from your client for either of the two issues? And maybe we just put it over to them.
I mean, I think that's probably the most prudent thing to do. Again, I would suspect my client would be amenable to that, but I just don't have authority to commit to that today. I would hope to get a response from them within a week's time. As I mentioned to Mr. Evanchek in the breakout room, I do have a client contact that is out of the office, to my understanding, this week and perhaps part of next. So that may delay the process a little bit. But again, I would hopefully get a response within a week or two.
I think that's unacceptable. I mean, I've been waiting a long time for this to be resolved. There's got to be somebody else that can handle that for your client.
Ms. Butler, it's not a defense issue. It's this court's issue. When the file was last here in January, I should have put different measures in place so that the case did not go off of the track. It's not either of the attorneys. It's me.
Okay.
It's me. I knew that there had not been an order. I thought the parties had worked something out. When they brought it back to my attention, I got it back on the docket. So please don't charge this to Mr. O'Connell.
Okay. Thank you, Your Honor.
What I will do, I'm looking at, I didn't necessarily want to put you over to my next civil date, but that's only July the 6th. And if you, before the July, if I say we'll adjourn this pretrial to July the 6th, if the two of you talk and want to do the case evaluation and submit an order for case evaluation, we'll get it transferred out for case evaluation. Or if you reach back out and say, no, we want to do the in-house mediation with Judge Green, we'll get a Judge Green date. But I want to put that July 6th control date in and keep a better eye on this file.
Yeah, but we just need to, sorry, Your Honor, we just need to call, if we did reach that agreement on the mediation, we just need to call you or call your office or email your office or.
You could email my secretary. She'll put her email in the chat to you, or you can, Marianne, if you want to do your email or your phone number and extension so that these gentlemen can reach back out before that July the 6th, 2022 date. I'll say 9:30 a.m. for the adjourned pretrial, but if we receive something from you in the interim that puts the case on a different track, Marianne will bring the file to me and we'll get it updated and get you where you need to be.
Yeah, I'm already here at 9 o'clock on that date anyway, so that works. But if you want to
okay,
closer to that 9 o'clock time, that would probably work a little bit better too.
I just don't know what else is scheduled. So if we'll say 9:30 for now, just so that we can, so that I know that we're not rushing. And based on your conversation this morning, think that you will probably reach back out before that July 6th date with a resolution, well, not resolution, but some direction on how we're proceeding, case evaluation or mediation.
I would hope so, Your Honor, yes.
Okay. Anything else on behalf of the plaintiff?
No, Your Honor, I think we got everything, and hopefully we can get this mediation. It's good to know that yourself and Judge Green are available for mediation over there. I hate setting these cases for case evaluation when we for such small dollar amounts.
Anything else on behalf of the defendant?
No, Your Honor, I'll be in touch with my client and Mr. Evancheck accordingly. Thank you.
I appreciate that. Thank you for your patience in getting this matter moving again. Thank you for your patience this morning, Ms. Butler. Everyone have a good day. I'll
Thank
see
you.
in July, if not sooner.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. Mr. Joseph, if you're available.
I am here.
This is 220921LT. This is Southport Apartments versus Hemingway McLawn.
Yes. Hello.
Thank you, Your Honor. Joe Joseph on behalf of the plaintiff.
Ma'am, state your name for the record, please.
Sonisa Hemingway McGlawn.
Thank you. Today is the day and time set for hearing on plaintiff's request to lift the SARA stay. That stay went into effect on March the 23rd, 2022. 76 days have passed since entry of that stay. Mr. Joseph, has your client received payment in full?
No, Judge, at this time, there's a balance, $6,707.16. That's inclusive of the court costs.
Ma'am, have you received any update from the SARA program regarding funding of your application?
Yes, ma'am. And I also received legal aid, and there's a few things that happened. Sarah.
Ma'am, I need you to, ma'am.
Yes, ma'am.
I can barely hear you. I just need you to speak up, please.
Okay. Can you hear me now?
Yes, ma'am.
Okay. Yes, ma'am. Sarah sent me a email, and they said that mine is being processed. Mine is being processed now, and I have that email. I have a copy of that. But also, it's an issue. I talked to legal aid. I had renewed my lease, and my balance is very high because I renewed my lease. I have a copy of that, and then I received something in the mail recently saying that I'm now put on month-to-month rent, which it took it to $1,500. But originally, my new lease is for $1,024. So it took my balance of me on. So legal aid, I talked to Lakeshore, and they said that's an issue because if I submitted my lease agreement to Sarah, and then if they're submitting something else totally different, that could be an issue. But Sarah said they're processing me now.
So, ma'am, are you saying that the $6,707.16 balance is incorrect?
Yes, ma'am. I signed my lease. This is my second lease. And so I have my new lease agreement, which started in March. And then I received a letter in the mail recently saying that I'm on a month-to-month basis now, which is $1,500. But my lease is for $1,024. So it took my balance of what I owe higher, saying that I'm on month-to-month now. But I have a lease agreement. So I called Lakeshore, and they said that they don't know which, that it could create a problem with Sarah, because Sarah may be looking at two different things if they reached out to try to process me. That if Southport is saying I'm on month-to-month, that's saying $1,500 a month. But my lease, I submitted that to Sarah. It says $1,024 a month. But Sarah said that I am being processed now.
Mr. Joseph?
Yeah, so typically, Judge, I'm not really sure about this month-to-month and new lease. I show the ledger that does show that she's month-to-month starting in March. Typically, new leases are never agreed to until balances are brought to a zero. So I don't know if the new lease was like proposed as a new lease for when the account gets brought to a zero balance. But I don't show that. My client hasn't indicated that. So, our accounting doesn't indicate that either.
Yep, I have the lease in front of me. I can read off to you because I printed it out just in case I had to mail it in or anything. So I submitted that. This is what I submitted to Sarah. So I have it printed out in front of me, and then I have the letter that was mailed to me also in front of me, saying that I'm now on a month-to-month basis. But I submitted this.
Ma'am.
Yes, ma'am. Yes, ma'am.
You have a lease
Yes, ma'am.
in front of you right now. Hold on. You have a lease in front of you right now signed by your apartment complex?
Yes. Yep. With my initials on it, I did it via the my portal when they said that it was time for me to renew my lease.
And what is the date on that lease?
Let's see. It is March, beginning month, March, day 12, 2002. Ending date, March 6, 2003. Security deposit, 400. Additional security deposit, 0. Non-refundable fee, pet fee, NA. A monthly rent, $1,024. And then it has all of the things like amenities, and I pay for my parking lot.
What this court will do is lift the Sarah stay as more than 45 days have passed and there has not been payment in full or payment pursuant to the Sarah program. This court will not enter judgment at this time as Ms. McGlon is disputing the balance due and owing and the issue of a month-to-month and a renewal existing at the same time as some cause for concern. If we can set the matter for trial, or we can set the matter, I don't more call it an adjourned pretrial, Mr. Joseph, if you have a preference of how to proceed in this matter.
You know what, Judge? I think it's a pretty simple calculation. Frankly, it's not going to make that big of a difference. We're talking a couple $100. So I would say let's set it for trial. And worst case, if the court finds that it should have been, the lower amount, then that's fine. But we're getting too far that I'd want to delay it any further.
Today is the 6th. I'm sorry. Yes, ma'am.
Oh, no, I was going to say, do I need to submit also my email that I received from Sarah saying that I'm being processed?
Do you need to do what?
Do I need to submit my email, the email letter that I received from Sarah saying that I'm being processed? Do I need to submit that or anything?
I don't know that I don't think there's a dispute, ma'am. It's just not been paid. And the administrative order that allowed for entry of the stay also allows for the stay to be lifted if payment's not made within a certain period of time. And it being in process just lets us know that your application is still pending, but we can't stay in process. We have to do something. I'm looking at the calendar for a date.
Okay.
Mary Ann, I had July 8th listed as dates, but is there something sooner? 24th sounds like a bad date for some reason. Why are you laughing, Mr. Joseph?
Because my wife just said something. I believe the 24th was like a astrologically bad date, and she just said it in passing because of something she read. So you said that, and I'm like, oh, maybe it is a bad date.
Well, don't leave. I'm looking at the 24th as a possibility. I just have to go grab a calendar.
Okay.
To make sure. I'm looking at Friday, June 24th at 10 a.m.
That works for us.
Live or Zoom? Do you have a preference, Mr. Joseph?
It doesn't matter. We'll have our client by Zoom, and we can submit the ledger. I think really just the issue is whether it's month to month or whether it's supposed to be controlled by that the new lease that was allegedly signed. So
Trial is set for June the 24th, 2022. That's a Friday at 10 a.m. back by Zoom. Ma'am, if there are documents that you want the court to consider, you need to submit them to the court. Anything you send to the court, you need to send to the plaintiff's attorney as well.
Yes, ma'am.
Ma'am, do you have the ability to Zoom with a video?
I don't know what, I'm able to get in with no problem. It kept giving me an error and saying I was unable to connect. It gave me some error code each time. It wouldn't let me get in the meeting room at all, and it kept kicking me out. So I don't know what that was about. I'm gonna try again to make sure it's nothing on if it's my phone or something. I'm gonna check it out to make sure.
Okay. Anything else on behalf of the plaintiff?
oh, nothing further, Judge.
Anything else, ma'am?
No, ma'am. Thank you.
Okay. I will see you both back. Well, I'll see somebody from plaintiff's office here on June 24th at 10 a.m. Have a good day.
Thank you. You
Thank
too.
you.
Thank you.
Bye-bye.
Good morning, sir. We're just waiting for Mr. Long to appear. So whenever he appears, we'll get your case called, get you on your way.
I'm sorry, Your Honor. I did not realize you were talking to me. Good morning.
You thought I was just randomly screaming out to the universe. I know it's weird, but you're the only one on my Zoom screen right now.
Oh, see, and I had myself muted and I had you behind a document, so I didn't even see that there was nobody else in here.
You're fine. They're used to me talking to myself, so it's not.
Those courtrooms look really nice. It'd be nice to actually see them.
Whenever you want to come in, we're open to the public. We've been open for quite some time.
Yeah, I came in there to file and I'm like, they're really doing a good job with these new courthouses. I just didn't go and look at the courtrooms, I guess.
Well, it's a big step up from the last building.
That's like the Inkster Court. I don't know if you were ever in that one when it was the old building. And then when they built the new one, it was like, whoa.
You don't like the old building where you have to scoot around the line to get into the waiting room? That's nice.
Or Hamtramck, where it's an old mental hospital. It's a good one.
But they've at least made the courtroom a nicer courtroom now.
Yes.
Where it used to be, a little scary. You go into certain rooms, there's still dripping water in the old stretchers. Or, oh no, old Highland Park.
Oh,
Back when
Highland.
it was on Gerald. Mhm.
Yes. Yeah, you gotta hand it to the government with their creativity of repurposing old buildings. But sometimes I don't think they think it all the way out.
That courtroom was a beautiful courtroom, the one where you walked up the stairs in Highland Park. That's where it originally was. That was a nice room when they were downstairs in the pine paneling room. That was a
Yes.
little different. Anyway, you're scheduled at 10:30. I allow about 15 minutes after the scheduled start time for Mr. Long to appear. I don't know if you want to reach out to him, if you all have had conversation.
We haven't. I just got his pleadings Friday in the afternoon, so. It's the only conversation. I didn't even know he was on the case till I got that, so. All right, I'll mute myself, and as soon as I hear him pop in, I'll be back.
Thank you, sir. Marianne, I'm not leaving. I'm just taking the files to Taylor.
Okay.
580.
707
Mhm.
888.
Good morning.
Good morning.
Mr. and Mrs. McIntosh, I just wanted you to know that we could hear you sound like you're reading out someone's phone number.
Oh, no, we were just trying to get the correct number to log into Zoom and just, going back and forth to make sure that it was the correct number. Because one of the reasons why we're late was because we received the wrong Zoom information.
You're not late. You're
Okay.
fine.
Okay. All right. Thank you.
Thank you.
You're welcome. Just waiting for Mr. Long to connect his audio.
Good morning, Judge Martin. Can you hear me?
I can hear you, but I can't see you.
Yeah, see me. Okay. Unusual. I see you and I can see myself.
There we are.
Okay.
Do you need to speak to opposing counsel before the case is called, sir?
Yes, I would like to speak with opposing counsel briefly if you would.
Mary
Yeah,
Ann, we'll get you
something.
moved into a breakout room.
Okay.
This is 220458 GC. This is Sonia Bonnie McIntosh, Edward McIntosh versus Speed Miller and Arlena Miller Brown. May I have your appearances, please?
Attorney George Long appearing on behalf of the plaintiff, Edward McIntosh and Sonia Bonnie McIntosh, P79687.
Attorney Nicholas Rhino Pileski appearing on behalf of the defendants.
Thank you, sir. Today is a day and time set for the first pretrial in this matter. This case started as a small claims matter was removed to the general civil docket. The court has also received plaintiff's motion for leave to amend the pleading. For purposes of the motion, Mr. Paluski, you indicated that you just received it.
Yes, Your Honor, I was not properly served with this motion, nor do I believe that it's appropriate in this matter. More specifically, I think that their motion should be denied outright because, Your Honor, this motion was dated May 18th, 2022. He didn't mail it out till 5/31/2022. Under the rules for service, that motion would have been needed to be mailed 9 days prior to this hearing. At best, Your Honor, assuming it went out, because you don't count that day, 1, 2, 3, 4, 5, 6 days prior to this motion. Your Honor, based upon that, service is not proper, nor was I given a proper chance to respond. I think the motion should be denied outright because of that. He had almost 15 days from the date he signed this motion to serve it, and he refused because he'd rather do it by surprise.
Sir, would the more appropriate remedy be to adjourn hearing on the motion and allow you an opportunity to respond?
I don't believe so, Your Honor, because when we look at this as a totality of circumstances, this case was originally filed in January. That they went to mediation with the court. So the parties have already participated. Things have already happened in this case. And typically, yes, you would have the chance to amend within 14 days of the filing of an answer. But the parties have already appeared on this. The parties have already started to move this forward. Nothing in their complaint or in what they're alleging they want to amend says that they're even going to name the proper party. And because of that, this is going to be ripe for summary disposition. They've had almost 6 months to do what they're trying to do today, which is the only reason that I believe that it wouldn't be appropriate to move it out, simply because they've had all this time to amend and everything else, but instead they've chosen this point to do that. So I don't believe that it would be appropriate. I think the motion should be denied outright.
Mr. Long?
Your Honor, I believe that the motion should be adjourned to give attorney defense account the opportunity to respond. The defendants were served by the 34th District Court in accordance to the court rules. He's appeared giving notice that he's here to answer this complaint. If he's not properly prepared, then an adjournment should be in order, Your Honor. We believe the interest of justice should prevail, and that my client should be given leave to amend this complaint. There's no process that would unfairly prejudice the defendants. The defendants are on notice of all charges or all allegations in the complaint, and they should be prepared to defend all allegations in the complaint.
Actually, Your Honor, it does prejudice my clients because originally this was a breach of contract, and now they're trying to add multiple other counts, including negligence, intentional infliction of emotional distress, which, Your Honor, as we all know, that's going to be almost impossible to prove, conversion, and any other relief. Your Honor, this is at best a bullying tactic in an attempt to force a settlement. Once again, they're only looking to add counts. They're not even considering filing with the proper parties. We're going to be filing a motion for summary disposition based on improper parties or parties or necessary parties not being added. So nonetheless, no, Your Honor, everybody would be extremely prejudiced by this, especially 6 months in after the complaint has been filed.
Again, Your Honor, this is the first allegation of prejudice after I mentioned prejudice, that there was no prejudice. Again, the allegations in the complaint were stated in the original complaint. The defendants responded to the original complaint, and therefore they have notice of the pleadings and the allegations, and they should be prepared again to defend each and every allegation and every claim in the complaint, Your Honor. Furthermore, we believe the interest of
Mr. Long, with that argument, if your argument is that the defendants had responded and have had every opportunity to defend against the allegations, why would there be a need to expand the allegations put forth by the plaintiffs?
Well, in regards to, let me restate that, Your Honor, in regards to what their position is today, is that they haven't had an opportunity to respond. They have had an opportunity, and they should be prepared to respond here today, Your Honor.
Your Honor, more specifically, we said we haven't had a chance to respond to this motion because it was improperly served. The Michigan court rules are very clear upon how documents are supposed to be served, including motions. Mr. Long had this motion in his possession for almost 2 weeks and decided to mail it out after the deadline. My client should not be prejudiced for his malpractice.
Again, Your Honor, the court properly served the defendants by mailing as after the motion was filed with the court.
Here's the issue. When people file these small claims affidavits, they're limited to the few lines. Very rarely do they attach a very detailed explanation of where they are and what their allegations are. Once it's removed and the attorneys become involved, I know that there is the effort to neaten things up and clean things up. So what this court will do is adjourn hearing on this matter. Mr. Opalewski, how long would it take you to file a formal response to the plaintiff's motion?
Your Honor, I would need to do a little bit of research on the matter. I would say a minimum of 2 weeks because I anticipate, unless I find something crazy, a brief needing to be compelled or a brief being sought. So.
I have no objections to it. Go ahead,
The
Your
court
Honor.
will adjourn the pretrial in motion to July the 6th, 2022 at 10 a.m. That will be back by Zoom, back with me. Defense counsel has received the motion, will file a response to it, and we'll hear argument on the motion on that date, as well as conduct a true pretrial where we'll set some dates. And if there's any discovery requested by and between the parties, unless you want to take that up now, if you'd rather wait until we possibly expand the complaint before we discuss.
Well, Your Honor, I think that we wouldn't, if the court's inclined to open discovery today, I mean, especially since they're indicating that they're going to claim intentional infliction of emotional distress. Your Honor, we're going to need depositions. We're going to need thorough discovery. I would give it at least 90 days plus depositions.
That's why I'm saying maybe we'll wait for this discovery conversation on that July 6th hearing, because I want you to have the opportunity to file a formal response to the motion and us kind of dig into how much we would possibly expand the complaint, if at all. I don't know what happened between the court received the motion on May the 18th. I'm not sure what happened between then and the time that you received your copy of it, sir. So don't want your client to not have the opportunity to submit a full and formal response.
Wonderful, Your Honor.
Anything else, Mr. Long?
No, Your Honor, thank you very much.
Anything else, sir?
Just, Your Honor, would the court reserve attorney's fees for having to respond to this?
I object, Your Honor, attorney fees, the party again, he's appeared here with the intent, I would think, to respond to the motion. He has a copy of the motion. He's not prepared to respond to the motion, Your Honor.
Your Honor, I'm
It's
here
not a
because
question of not being prepared to respond. He's very clearly made the record that he didn't receive it until last week without the requisite number of days between the date of service and the hearing date. So we will stop whatever this is, and we'll take it up again on July the 6th, 2022 at 10 a.m.
wonderful. Thank
Anything
you.
else on behalf
you,
of the
Your
defendants?
No,
Thank
Your
you.
Honor.
See you in July.
Thank you.
There's a person. Why does that look like Mr.? It looks like what Mr. McIntosh was wearing. Nope. Thank you. Good morning. You're muted, ma'am.
Sorry, my court case is with the Michigan Schools and Government Credit Union.
Your name?
Tiandra Reeves.
Ms. Reeves, I have not seen an attorney from the plaintiff's office as of yet. If you sit tight, we'll get your case called and get you on your way as soon as possible, okay?
All right, thank you.
You're welcome.
No, bye-bye. So when I just disconnect?
No, sit right where you are. Just mute yourself.
Okay.
Thank you.
Mm-hmm.
Thank you. Thank you for renaming her for me. Good morning, sir. How are you?
Good morning. Good.
What case are you here for this morning?
So I'm here for plaintiff on 141.
Oh, okay, Reeves?
Michigan Schools versus Gander Reeves. Yes.
She is here. Do you need to go into a breakout room with her?
We can.
Okay, Miss Reeves, can you hear me? Hi, you're going to see an invitation to join a breakout room. Just click on that and the attorney will speak with you, okay?
Okay.
We had some cloudy conditions early. That rain will come to an end. It's already come to an end. Cloudy skies.
Welcome back, Mr. Nate.
You?
Do you need to go into a breakout room with Miss McIntyre?
I mean, I'm always happy to if she'd like. I know there wasn't much we could do last time we had a hearing, but maybe there's an update. So I'm
Okay.
happy.
Okay, Miss McIntyre, you're going to receive an invitation to go into a breakout room with the attorney, okay?
Okay.
Thank you. Sir, was that enough time?
Yes, that's enough time.
All right, thank you.
Thank you.
Good morning, Mr. Beers.
Morning.
This is 215141 GC, Michigan Schools versus Reeves. May I have your appearances, please?
Good morning, Your Honor. Jeffrey Beers, B41693 on behalf of plaintiff Michigan Schools.
And ma'am, if you would state your name for the record, please.
My name is Tiandra Reeves.
Thank you. Today is the day and time set for hearing. Set for the pretrial in the matter, final pretrial. The parties have had an opportunity to speak. How are we proceeding this morning, sir?
We had an opportunity to speak this morning. We were not able to resolve. Plaintiff served our discovery on May 9th. As of yet, we have not received a response.
Ms. Reese, did you receive the discovery request from plaintiff's office?
No, ma'am.
Have you received anything from them since we appeared on April the 5th?
No, ma'am.
Ma'am, did you receive the notice from the court to appear today?
I received that back. Yeah, I have it right here. Not too long after.
The reason I'm asking is that plaintiff's proof of service for their discovery request indicates the exact same address that the court used. And if you're receiving court mail, but you're not receiving the mail from plaintiff's attorney, yes, that's a little bit of a cause for concern. Mr. Beers, how would you like to proceed, sir?
Gunnar, if you like, I can reserve our discovery request. We can send by a FedEx.
If that's how you'd like to proceed, sir, that's fine.
Otherwise, I guess we would like to, well, I guess we would rather proceed with our motion for summary. We would like to file a motion for summary, rather.
How long would it take you to get that motion filed, sir?
Let's see here. Can we file it within 30 days?
And have it heard on August the 2nd?
That would be
Can
fine.
you back into that date? August the 2nd, 2022 at 9 a.m. as the adjourned final pretrial motion for summary date.
That sounds good.
Can I speak? Like, I don't understand what's going on right now. So, I wanted to set up arrangements to make payments. I offered him $500. That's all I had. I'm self-employed, and at the time I offered him the money, I had it. Now I don't. And yes.
You're offering him a monthly payment of $500, or you're
No, that was just a one-time fee. I'm self-employed. I don't make very much money. I have a dessert shop, and it's inside the mall. And during the summer hours, the mall slows down because people go on vacation, so it's not much traffic. So, like, all this court time, the time that I'm taking out is taken away from me going to work. I don't want to keep going to court. If I can just make payments, or I don't know.
Once I stopped with the date information, I would have explained to you as much as I could.
I'm sorry.
Cannot help you. That's okay. No, you're fine. I can't help you navigate this process, but what I can do is explain a little of what we're doing. When we were here on April the 5th, discovery opened. And what I typically say when discovery opens to people representing themselves is that you might get things from the plaintiff's office that require you to respond to them and send it back to them, answer their questions, or provide the documents they seek. And that's what discovery is. And Mr. Beers' indications that he sent, or his office sent you discovery requests, and those discovery requests were titled Plaintiff's First Set of Interrogatories, Requests for Admissions, and Requests for Production of Documents. That would have been questions for you to answer, things you would say admit, deny, and to return certain documents.
Okay, I never received that.
That's okay.
Mhm.
So what he's indicated is that his office is going to be filing a motion. The motion is going to ask the court to enter a judgment against you. We will hear that motion on August the 2nd at 9 a.m. That is what that's what the new date was I was given. If you make an offer to make payments on the judgment if you offer to make payments on the balance that is owed, that's a conversation you can have with his office between now and August. You don't have to wait until you're back in court on August the 2nd. If you want to talk to him right now, I'm sure he'd entertain it, but that's a conversation for you to have. I can't force you into a payment plan. That's something you work out. You sign an agreement, you send it to the court, and the court will sign it, but that's something you would have to do. Otherwise, we'll be back here on August the 2nd for the motion and final pretrial.
Okay.
Does that make sense to you, Ms. Reeves?
Yes.
Anything else, Mr. Beers?
I think if that's nothing further.
Anything else, Ms. Reeves?
No, that'll be all.
Thank you. We're all set. Have a good day.
You too. Thank you.
Thank you. Mr. Nate and Ms. McIntyre.
Yes, Your Honor.
This is 215981GC LVMV funding versus McIntyre. May I have your appearances, please?
My appearance?
Just state your name for me, ma'am.
Oh, Doretha McIntyre.
Thank you. And we just lost the attorney. I'm not sure what happened to him.
Oh, well, hopefully he'll be
Oh,
back.
here he is. He's
Oh, okay.
popping right back in. Your appearance, sir.
Sorry about that. Preston Nate, LVNV.
Thank you. Today is the day and time set for the final pretrial and motion for summary disposition. The parties have had an opportunity to speak. Is there a resolution this morning, Mr. Nate?
I'm happy to say that there is. We're going to go ahead and get Ms. McIntyre a proposed consent judgment with the payment plan. The amounts on it looks like it's going to be a total judgment, including the costs of $9,850.96. And she's going to go ahead and make a payment plan of $100 a month starting July 20th, 2022. Consent judgment.
July 30th, 30?
20.
20th, 20, okay. Ms. McIntyre, were you able to hear Mr. Nate just now?
Yes, I was, Your Honor.
And ma'am, you wish to agree that there's a total of $9,850.96 due?
Well, not really, but yes. Yes.
Are you sure?
But if I don't agree to that, I mean, then I got the paperwork. I mean, it's a lot of interest charges. Oh, that's what I forgot to ask him, because it's interest charges and stuff in that. So what about the interest? Is this thing still accruing interest and all of that? Or has the interest stopped?
It has stopped. But with the judgment, I think there's like a 1% interest rate on there. So it's not as bad as the original loan, but I think what we do put on is 1%.
1% per what? Per month?
Well, if you're concerned about the interest, Ms. McIntyre, and if you're pretty confident about making those payments, what we can do then, instead of a consent judgment, we'll keep the same terms and everything, but we could do a conditional dismissal. That way you'd avoid any question about interest, because there wouldn't be any. We'd just dismiss the case, and you'd make payments on that amount like we've talked about, but that way you wouldn't have to worry about that. Does that sound a little bit better?
That does sound a little bit better, because at $100 a month, I'm looking at, I mean, even at 1% a month, I'm looking at this thing going exponentially.
I do understand that concern. So with the size of your balance, I get that as a concern, but let's do that instead, Your Honor. So we'll, instead of a consent judgment, we'll do a conditional dismissal with the same terms.
Conditional dismissal in that same amount, and Ms. McIntyre, $100 per month beginning on July 20th?
Correct, Your Honor.
Mr. Nate will get that to you. You sign it, you get it back to him. He'll file it with the court, and the court will sign it. Copies will be mailed to you, okay?
Okay.
Anything else in this matter, sir?
No, you are. That's fine. Thank you.
And
Anything
thank
else, Ms.
you.
McIntyre?
I appreciate everybody. So thank you so much.
You're welcome.
You're so very welcome. Have a great day. Mr. Nate,
You
have a good
too.
day. Good to see you.
You bet. That was
Okay.
my last one with you. So we'll see you next time.
Thank you.
Marianne, I'll take us down to our afternoon docket, please.
Okay.
Thank you.